to Association for Homeschooling, and then they're represented by May Yuda Dive. Over to you, May Dive.
Thank you very much. I appreciate it. My name is Jennifer Honeycomb. I will be presenting on behalf of the Association for Homeschoolers and very grateful to be here. Thank you.
Oh, okay. You're welcome.
We strongly believe that it is a parent's God-given right and responsibility to make the decisions surrounding the well-being and education of our children. Thankfully, we are not alone in that conviction. Supported by many of you, by human rights law and international law, and by a robust home education community, we are here today because we believe we can work together to get this right. In its current form, we believe that this bill must be amended significantly. We have three main concerns. If left unchanged, the human rights of families are infringed upon with wording which contradicts the treaties that South Africa has agreed to uphold with their international partners. It lacks the necessary research and data that must be provided before implementation. And lastly, it does not match in wording what has been promised by the authors. Thank you for your consideration as I address these concerns. I'd first like to address the concern regarding human rights, specifically the rights of the family. Most of our other complaints stem from this infringement. South Africa has signed multiple international agreements affirming their commitment to protecting the rights of families. Trust is also a right. International law trusts parents to do the right thing, and it says that governments should not interfere with parents who can be trusted, and that a parent's choice is trustworthy until proven otherwise. Here are a couple of examples. The Universal Declaration of Human Rights says, parents have a prior right to choose the kind of education that shall be given to their children. South Africa signed this declaration and it was ratified as recently as 1996. From the International Covenant on Civil and Political Rights, ratified by South Africa in 1998, the states parties to the present covenant undertake to have respect for the liberty of parents and, when applicable, legal guardians to ensure the religious and moral education of their children in conformity with their own convictions. South Africa signed and then ratified in 1997 the African Charter on the Rights and Welfare of the Child. It states that parties to the present charter shall respect the rights and duties of parents and, where applicable, of legal guardians to choose for their children schools other than those established by public authorities which conform to such minimum standards may be approved by the state to ensure the religious and moral education of the child in a manner with the evolving capabilities of the child. And further on, the family shall be the natural unit and basis of society. It shall enjoy the protection and support of the state for its establishment and development. And again, from the UDHR, the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. So how does this bill undermine the human rights principles outlined in these treaties? Beginning with the required registration, parents are required to seek permission from the government to exercise a right that already belongs to us. The right to choose whatever education we deem best for our children is our right and our responsibility. South Africa recognizes this. Yet, the wording of this portion of the bill would strip us of that right by forcing us to seek permission to exercise it. Although this section states that the head of department needs to approve applications, it follows by saying, if he or she is satisfied that home education is in the best interest of the learner. However, again, this is a violation of a parent's right to decide what is best for their child, and also a violation of the child's right to be advocated for by the people who know them best, love them most, and understand what they need to thrive. Most home educating families are not against a registration process, whereby we let the government know of our plans to home educate. We understand this knowledge can help with state school planning and zoning, and can even assist in areas of research where presently there is none. But it must not infringe on a parent's right to make that decision. I'd like to pause for a moment to discuss some of the definitions found in the bill regarding Clause 35. It's important to do so to provide clarity as we move forward. What is meant by basic education? The current definition reads, basic education includes grade R to grade 12 as evidenced in the National Curriculum Statement. Since the National Curriculum is a provider of basic education, the definition of basic education itself should exist apart from any curriculum provider. We feel our suggested alternative, basic education, means pre-tertiary education and may include education in public schools, independent education, including home education, and other forms of education recognized in legislature. We believe this provides a more thorough and inclusive definition of basic education and would like to see this definition amended. The next definition is home education. The essence of what home education entails is missing from the definition, and we feel that this missing portion is necessary to protect the freedom of choice that home education offers. This was a major concern in the public hearings. There were thousands of submissions on this point alone. Protecting freedom of curriculum choice and methodology. Thankfully, again, Mr. Nlibe provided clarity when he assured us on multiple occasions that we are free to choose whatever curriculum we want to use whatever methodology we feel is best, nothing tied to the national curriculum, only that it must not be lower than the basic standard. And so we were again encouraged to put forth the following proposal to correct and clarify the definition of home education. Home education means a form of non-school-based education, alternative to compulsory school attendance, managed and controlled by the parent and where appropriate the learner, that shall include the choice of educational method and or curriculum, assessment methodology, and educational resources. Despite this definition on home education being crafted by a community of experts in the field of home education, and in agreement with Mr. Nlibe's assertions, these changes have not been adopted. The last definition that I would like to address is that of competent assessor. Another major concern brought to the public hearings by thousands of concerned families was the method of assessment. For clarity, I just want to add that as home educators, assessment is part of our daily routines. We are constantly assessing, adjusting, recalibrating, as it's in the best interest of our children to do so. It is not assessment itself that is of concern, but the method of assessment. Assessment is linked to goals, and goals are set by the chosen curriculum. Most all curricula are designed to meet a certain standard, but most are not aligned to the national curriculum, and being forced to assess according to a different methodology is akin to forcing the national curriculum on home educators. In thousands of submissions, parents voiced their concerns. Mr. Nlibe heard us loud and clear, responding to us with great assurances that we may choose our own assessors, that assessments may be based on our chosen curriculum and methodology, and even declaring that they were not experts in this area, have no desire to become experts, and we may proceed with assessments as our chosen curriculum entails. And yet, no amendments have been made to this section on assessment either. We request that the bill be amended to include A body, a person or body registered with the provider of a curriculum used by the learner, a registered professional capable of performing academic assessment independently of curriculum, or a standardized testing service provider, including online testing. This is what has already been agreed upon verbally, but needs to appear in the bill to ensure that the expressed intent is realized. The state will argue that they have a responsibility to fulfill, and we don't disagree with them completely. There is a place for regulation, but to determine what type of regulation is acceptable, we need some information to guide us. Specifically, what does the research show? What are the needs this legislation will solve? What impact will these new regulations have on families and on the state? Our second concern is regarding the research that was necessary to write regulations for the home education sector. The department stated that they do not have the needed research to know what impact this bill will have on the state or on homeschoolers. Furthermore, although they have set out to regulate a whole sector of home educating families, they have admitted numerous times that they are doing so despite not knowing how home education even works. The purpose of a SEIA report is to understand the full costs of regulation and especially the impact on the economy. This is to avoid a situation where legislators make laws that are unaffordable by the public or the state and where the benefits do not justify the costs. The SEIA that accompanies a bill must contain all the necessary information to ensure that all intended and unintended consequences of the bill are considered. However, the home education section of SEIA is incomplete and lacks necessary information. Since we do not have any localized research or a SEIA report that can address these questions, I would like to refer to the international research that we do have. Homeschooling began to see a rebirth in the United States in the 1960s. 60 years later, you can see the worldwide growth. Other international studies have also been conducted with similar results, but most of the international research comes out of the United States, where they currently have 6 million home-educated students. The decades of research that have been conducted there have led to over 2,000 articles, studies, and reports showing overwhelming evidence of the benefits of home education on students and on society. This accumulation of research has led to changes in policy. The U.S. found that home education saves them $100 billion per year, provides on average better results, and furthermore, home learners who lived in states with stringent regulations did not perform better than homeschooled students from no regulation states. In fact, the burden to the state and home educating families could not be justified as there was no benefit. And so, in addition to the savings of $100 billion per year, U.S. states are progressively loosening regulations, with over 2/3 of the U.S. states now offering no to very low regulation, thereby reducing the burden on families and the state. That is the trend based on the latest international research. Here you can see that all of the blue states offer no to very low regulations, and the other states are moving in that direction as they work to reduce unnecessary burden to the state. We're talking a lot about burden versus benefit here, but what will be the burden to the state? Can they manage the additional admin? How many additional workers will they need to service the homeschooling sector? What will be the financial burden to home educating families? These families are already sacrificing financially to make this lifestyle decision. They are saving the state approximately 20,000 Rand per student per year, and they are dedicating themselves to what they believe is in the best interests of their child. Yet, they must now pay for regular assessments as well out of their own pocket when officials admit they do not know how they will even process the reports. Families who have already made the biggest personal sacrifices to home educate will likely feel this impact the most. The bottom line is, we can't answer these questions, and neither can the state. The SEIA report does not address these crucial issues at all. I do have to note that an attempt was made to estimate costs for assessment, but the calculations were done on grades 10 to 12, which falls outside the scope of home education as specified in the Act. These calculations are therefore irrelevant to the actual cost of the bill, making the SEIA report in regard to home education useless. The last thing I would like to address before closing are some of the specific clauses that have caused the most concern within our community and of which we have been most vocal about throughout this whole public participation process. Like the others, you will notice that these have also been agreed upon verbally by Mr. Nlibe, but again, without any changes made to the actual bill. Curriculum choice. We already discussed the definition of basic education earlier, but you can see how important it is that we get this right. All curricula must meet a basic standard, but the national curriculum cannot be that standard. It must also seek to meet the basic standard. This particular section deals with curriculum choice. The wording, the proposed home education program is suitable for the learner's age, grade level, and ability, and predominantly covers the acquisition of content and skills at least comparable to the relevant national curriculum determined by the minister, is of concern. Home educated students tend to progress in their learning according to mastery. When they've mastered a module, they move on. If they haven't mastered a module, they may need to keep working until they grasp the concept. Because they don't need to move along with a class of others, they can proceed at the speed which best meets their needs and challenges their giftings. Legislating a program that is attached to age or grade level is therefore problematic. We would suggest the wording undertakes to ensure standards to be maintained will not be inferior to the standards in comparable public schools. We believe this meets with both the state's intent as well as allows for the freedom we need to educate our children well. Assessment. Section S51 2B3 reads, arrange for the learner's educational attainment to be assessed by a competent assessor at the end of each phase up to the end of the year in which the learner reaches the age of 15 years or completes grade 9, whichever occurs first, and against a standard that is not inferior to the standard determined in the National Curriculum Statement. We propose the following change. Arrange for the learner's educational attainment to be assessed by a competent assessor at intervals suitable to the curriculum, educational methodology, or approach chosen by the family, and using an assessment methodology suitable to the curriculum, educational methodology, or approach chosen by the family, and against a standard that is not inferior to the standards in comparable public schools. Excuse me. The next section reads, submit to the head of department at the end of each phase and as evidence of the learner's educational attainment, the learner's assessment report signed by the competent assessor. We propose submit to the head of department at intervals suitable to the curriculum, educational methodology, or approach chosen by the family, the learner's assessment report signed by the competent assessor. We believe this change is in keeping with what has been fought for so passionately in the public hearings, promised verbally by Mr. Nlibe, and in the best interests of our children. I'll close with what I believe is our gravest concern. Section 5116 states, the minister may make regulations relating to registration for and the administration of home education. We ask that this be changed to, the minister must make regulations establishing a consultative body for home education in South Africa, constituted in terms of Section 11(1)(b) of the National Education Policy Act. This body must be representative of home educating parents and/or their chosen representatives. The minister may, in consultation with the consultative body for home education in South Africa, make regulations relating to the registration for home education. We cannot keep this section as is. It equates to writing the minister a blank check. Are we really in the process of writing a bill in a free, democratic society? For over 10 years, we have been trying to communicate our concerns to the DBE. We have largely been ignored. We turned up by the thousands to the public hearings to raise our concerns and bring forward personal testimonies, scientific research, and legal arguments. They didn't go unanswered. On the contrary, we were told that we were right. The state agrees with us, supports us. They trust us. They support our human rights, our parental rights, and our children's right to our advocacy. The DBE has promised us all of the major things that we are asking for on record. Yet still, those changes have not been made to the actual bill. This has happened to us over and over again throughout the years we have been trying to work with the DBE. And so we implore you to please amend the bill. Please don't pass it like this. We are so close to getting it right. But we cannot leave a clause at the very end that gives the minister the right to undo a decade of our blood, sweat, and tears as we have fought long and hard to retain the rights given to us by God, upheld by this precious country's Constitution, and we hope by all of you. Thank you very much for your time and your consideration on behalf of the Association for Homeschooling. Thank you.
Thanks for your contribution and engagement, Association for Homeschooling. Thank you very much. Honourable members, are there questions, clarity-seeking questions that we need to give to Mayor Dube? In the absence of any questions from